I'm Drew Stevenson, and this is a lecture for my professional responsibility class about Model Rule 7.1, Communication Concerning a Lawyer's Services. Now, this is the first rule in a section about the ABA's model rules about advertising and solicitation. And basically, this is a truthfulness rule or a rule against false advertising and solicitation. So 7.2 is going to be about advertising specifically and what you're allowed to do and not allowed to do. 7.3 is going to be about solicitation, by which we mean offering kind of live or in person to represent someone. But before we get to either of those rules, we have a general truthfulness requirement or a rule against false representations in any type of communication by the lawyer in trying to hold their firm out there and attract new clients. Also keep in mind that these rules were overhauled in 2018. So some of the older casebooks or study aids and things like that from before 2018 will be a little confusing because there were a few substantive changes to the rules and then also some sort of formalistic changes where they rearranged and renumbered some things even for the provisions they kept. And so let's take a look at the rules here. Also keep in mind, please, that as you go through this, that advertising is the area where we have the greatest variation state to state about ethics rules. And the ABA, of course, would like to have more uniformity, but there's when you are in practice, you should definitely check whatever your state's current rules are about advertising and solicitation. So 7.1 is pretty straightforward. It's one section. There's no A and B, separate sections with two sentences. A lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. By the way, the Supreme Court has upheld this when their lawyers have brought free speech challenges. The Supreme Court has said consistently that firms can have a strict truthfulness requirement or a strict prohibition against false advertising by lawyers. A communication is false or misleading if it contains a material misrepresentation of fact or law, or omits a fact necessary to make the statement considered as a whole not materially misleading. So please note, it's not just overt statements that you make. You can't avoid discipline by saying, well, I didn't actually say something untrue. If the misleading aspect of it was that you were selective about what you said or you omitted key details or facts to create the wrong impression. And the comments are going to clarify that, but just please keep in mind this can be the subject of a gotcha question on the MPRE. Could a lawyer be subject to discipline for what they don't say in their ad, for leaving out something that kind of creates a misleading impression? And the answer is yes. Okay, I'm going to hit the comments that are most likely to come up in test questions. So comment 2 to Rule 7.1 says, misleading or truthful statements are also prohibited by this rule. Make sure you understand that. Even a statement that is technically true could make a lawyer subject to discipline because it's misleading. So a truthful statement can be misleading by omitting a fact that's necessary to make the lawyer's communication as a whole not materially misleading. And so they give some examples here in comment 2. A truthful statement is also misleading if presented in a way that creates a substantial likelihood that a reasonable person would believe the lawyer's communication requires that that person to take further action when in fact no action is required. In other words, you run an ad or you do those robocall spam calls, leaving voicemails for people telling them that they may have a tax claim and they will forfeit it, or maybe could go to jail if they don't call your firm immediately. I've had voicemails like that left on my phone at the law school where someone is claiming that there may be an issue with some government agency and that the person receiving this could face fines or imprisonment if they don't call such and such company, and it's a scam. And so you're not allowed to do those types of things or suggest to people that they will forfeit a claim if they don't contact you immediately when there's no reason to think that that would happen. Comment 3, a communication that truthfully reports a lawyer's achievements on behalf of clients or former clients may be misleading if presented so as to lead a reasonable person to form an unjustified expectation that the same results could be obtained for other clients in similar matters without reference to the specific factual and legal circumstances of each client's case. And so these are the ads where either the lawyer is talking about other cases they've won. I won this client A $10 million. I won client B $20 million. How much am I going to win for you? And the implication is the next increment up, $30 million or something like that. Or some ads will do this with testimonials where it's the client talking, or a written statement from clients, a testimonial, and they all sound like, give the impression that this lawyer wins millions and millions of dollars for every client. And the problem is that there's a lot of prospective clients out there who really don't have a legal claim, or don't have won't be able to get the evidence together to prove their claim, or may have missed the statute of limitations for their claim already, and so forth. So obviously, results will vary depending on the factual and legal circumstances of each client's case. And this comment 3 basically says that needs to be in your ad. If you are going to refer to your successes with previous clients, then you need to include some kind of disclaimer that results may vary in your case, and so forth. Similarly, an unsubstantiated claim about a lawyer's or law firm's services or fees, or unsubstantiated comparison of the lawyer's or law firm's services or fees with those of other lawyers or law firms may be misleading if presented with such specificity as would lead a reasonable person to conclude that the comparison or claim can be substantiated. And we don't have a bright line here, but if you want to say something like you're the best looking lawyer in the state, or that you work the hardest, or maybe even just that you're kind of the best all around lawyer, and there's no real way to, you're not saying how, by what measure or anything like that, that might be okay. That you're the most, maybe your mother really loves you, so you're going to say that you're the most beloved lawyer in the state. On the other hand, saying something like, I win more than any other firm, or I've won more million-dollar verdicts than any other firm, that's a very specific claim that sounds verifiable or falsifiable. So don't say that unless it is absolutely and technically true, because that can be misleading. The same is true about your fees. Don't say things like, we charge lower fees than any other firm in the state, if there are legal aid clinics that represent people for free, because you're obviously not charging less than free. And so watch out about these sort of using hyperbole in these comparisons with all the other lawyers, or in your state or country or city or county or something like that. Also, saying something like, I'm undefeated in court, but you've never had a trial, right? It can be also similarly misleading. So watch out about some sort of unsubstantiated claim. I've never lost a case, but you've actually never done a case. That could be a misleading representation. And also watch out for this in test questions. Including a disclaimer or qualifying language may preclude a finding that the statement is likely to create an unjustified expectation or otherwise mislead the public. So as I mentioned before, if you're going to say, refer to previous clients that you won a lot of money for, or had a big success story, then it probably, almost certainly including a disclaimer, the results may vary in your case depending on the facts and laws governing each case. That will probably be an adequate disclaimer. Of course, you could have a test question that gives you something that no disclaimer could undo the lie, right? Where a lawyer is saying something like, I have won more trials than any other lawyer in the state, or any other lawyer in history, or something like that. And then you have a disclaimer that says something that's still pretty vague. The disclaimer might not be enough. So notice I put in bold here, may preclude a finding. It's not a for sure, but in practice, most of the time for test questions, if you see a disclaimer, the disclaimer will probably be effective in avoiding kind of the misleading nature of the representation in the ad. Okay, let's skip ahead to comment 5. Firm names and letterhead and other types of professional designations. This used to be a standalone rule, by the way, before 2018, and they moved the provision almost intact into comment 5 of Rule 7.1. We didn't really change it substantively, we just relocated it here. So firm names, letterhead, and professional designations still count as communications. And what that means for you is if your firm name is inherently untruthful, that counts as a violation of the rule. So it's not just the representations you make in the ad, what you call your firm in and of itself could be untruthful. So you can call your firm by the names of one of your partners, some of your partners, 10, or everybody who works there. If you want to have even include associates in your firm name, the model rules don't prohibit that. Also, deceased members, if there's a direct succession. So if you had the founding members of your firm 100 years ago and you've continued to use their names, you don't have to remove someone's name from the firm when they pass away, as long as it's still the same firm. You can also use a trade name as long as it's not false or misleading. So if you want to call yourself Advocates Incorporated or Lawyers for You or Lawsuits Are Us or something like that, as long as it's not misleading, then that would be okay. You can also, they had to put in here that you can have distinctive website addresses or social media usernames and so forth, as long as they're not misleading. So you can't have www.drewstevenson.com as your, that's my name, as the name of your firm, just to kind of misleadingly direct traffic to your site, like pick the name of a celebrity or something like that. That's misleading. On the other hand, if the name of your firm is Advocates Incorporated and you want to call yourself advocates.com or advocates.net or something like that, that would be okay. Now, here's what would be misleading, and pay attention to this because these show up in test questions. Implying a connection with a government agency. Really watch out for calling yourself the United States anything in your firm name. United States Lawyers, United States Advocates, United States Defenders, because it sounds like you are the Public Defender's Office, the Federal Public Defender's Office, or the Federal Solicitor General or Attorney General's office. So when in doubt, always avoid using either something that suggests the federal government, like federal or United States, or state names can also be problematic. And city, watch out for county of such and such, or city of such and such. Deceased lawyer if they were never associated with a firm. So don't pick a name of a lawyer who lived a long time ago and call your firm after them. That's not fair game. It needs to actually be someone who was associated with your firm. Also, you can't use the names of lawyers not associated who are alive and don't work with your firm or predecessor firms. So don't pick some famous lawyer and just name or someone who's now been put on the Supreme Court and name your firm after your favorite Supreme Court justice, for example. And the same would be true with non-lawyers, right? Don't call yourself the Oprah Winfrey law firm or the Donald Trump law firm. They're not lawyers. And so that might get you lots of web traffic and lots of clicks, but that's on the internet, but you're not allowed to name your firm after a non-lawyer. Nor are you allowed to name yourself after some sort of charitable legal services organization. Like, I'm sorry, the ACLU is already taken, Sierra Club is already taken. Now, if you use a trade name that does include a geographical region or name, like Springfield Legal Clinic, you might need to have an express statement that you are not a public legal aid organization to avoid a misleading implication. And so it's not an absolute prohibition on using the city where you are located as part of your firm's name. It probably would be if you said city of or town of Springfield. I think that would be misleading. And then here we're also worried about place name and then the phrase using the word clinic, which is going to give the impression that you're a legal aid clinic. So you may have to include a disclaimer every time you print your name. Comment 7. Lawyers may not imply or hold themselves out as practicing together in one firm if they're not a firm, as defined in Rule 1.0c, because to do so would be false and misleading. Now, first of all, you might want to take a minute at this point in the course or in your studies to look at the definition section in Rule 1.0. I don't make videos to go through the definitions, but here we are referencing a specific definition. So go ahead and look it up and read it through one time. It's not that earth-shattering, but it's kind of what you would expect for a definition of a law firm. Now, what this comment is talking about, though, is we have a modern practice where solo practitioners sometimes will be office mates or share an office suite. This can be very efficient and cost effective. So you want to reduce your overhead, and you find two or three or four other solo practitioners, and you rent out a big office suite together, and each of you kind of has your own private office that you work in, but you have a shared, you share your common space. You have a shared waiting room. You may share a receptionist and phone lines and computer network and Wi-Fi. You may even share and shared bathrooms and kitchen and so forth. And so there's nothing wrong with that. And it can create a better impression on the firm. It can keep your costs down and give you economies of scale. But your firm is you. So don't then say something like, have business cards on letterhead that says the lawyers at 123 Main Street, because that looks like you're working together as a firm, that there will be other people who may be looking over your shoulder or who could fill in for you on a case and so forth. And if you are a solo practitioner, you need to go ahead and make that clear, even if you're sharing office space or kind of practicing in the same location together. Again, this is increasingly common. It's very efficient, but it can create a misleading impression. Resist the urge, if you're sharing office space, to name your kind of collective together and hold it out like you're a firm when you are not legally associated as a law firm. Comment 8. It is misleading to use the name of a lawyer holding a public office in the name of a law firm. So this is a nice, very specific bright line rule that's super easy to turn into multiple choice questions for tests. Or in communications on the law firm's behalf. So the law firm, if they're running ads, can't say, hi, we're Mayor Jones's law firm. Or we're Governor so-and-so's law firm, or State Senator so-and-so's firm. It's very common, actually, for lawyers to run for state legislature and things like that. And sometimes those are sort of part-time jobs, right? You're only really working at the legislature when the legislature is in session. So a lot of those lawyers want to keep their practice and keep their spot at their firm. They don't quit their job, but the firm does need to remove you from their actual firm name if you are holding public office, even if you're still working there kind of in the off season and handling some cases and so forth. Again, we have a lot of lawyers in the state Senate where I live, and we could have a lawyer who is the small town mayor or county clerk part of the time and things like that. Now, it says substantial period. So obviously, if it takes a few days for your firm to do the name change and make it legal and get new business cards and letterheads, that's okay. But you can't let this go on for months and months. And the concern is that it will create the impression that the firm is somehow associated with that public office and the power of the government and so forth, if they're making it sound like a public official is also in charge of their firm. You can still have your job there. We have to remove you from the firm name. Okay, here's a review question to see if you've been paying attention. Can a lawyer be subject to discipline for omitting a crucial fact from an advertisement in order to make the advertisement slightly misleading? A, yes, because omissions can make an ad misleading and therefore untruthful, or B, no, only actions can constitute a violation of the model rules, not omissions. Hopefully you know the answer to this. This is supposed to be an easy question, and if not, you might not have been paying attention and need to rewatch the video. And that concludes our video about Model Rule 7.1.